Well, good afternoon to everybody. Thank you for joining the webinar. Just to introduce myself, my name is James Norman. I'm one of the partners at St James's Place. I am joined here by Marcus Hinckley, Stephanie Almeida, both from Hawksford, as well as Charles Edwards from St James's Place. So just to explain, I guess, the order of events today. So I'll very soon pass across to Marcus. Marcus can give you a bit of an overview of the need for a will, who will then pass over to Stephanie to talk about lasting power of attorney. We will then pass over to Charles Edwards, who can run you through inheritance tax and potential solutions to mitigate this. And then finally, we'll have a short Q&A section at the end. So do feel free to post questions in the chat during this webinar. And then I can field them to the other presenters right at the end. So all in all, it will last about an hour. As I said, please do give us some questions. Equally, there will be some feedback after the webinar as well as a recording. So we do welcome your feedback. So without further ado, I shall turn off my video and pass over to Marcus.
Hi there. Okay, I'll turn off my video so it's a little bit easier for me just to look at my slides. Today, what I'm going to talk about is the need for a will. The agenda for us is a will right for you? Do you need one? Why is it important if you do need one? Then deciding how many wills you need. You may need just one worldwide will, or you might consider that having multiple wills is a good idea. As James mentioned, my colleague Stephanie will talk about lasting powers of attorney, and we provide that service in both Singapore and the UK, which might be helpful. And then we'll talk specifically about our will services, what we offer, and the likely fees for that kind of service. So first of all, the big question of what legacy you leave behind. The death of a close loved one, especially when that person is the primary caregiver or the breadwinner, is enormously challenging. And leaving your affairs in disarray makes that challenge even harder for the ones you leave behind, especially for expats like myself and a number of you as well that are listening, who live outside of their home country. They're unlikely to have their extended family close by. Their extended family will probably need to participate in the process of either helping the remaining members of your family to return to their home country, maybe to help with the guardianship of children, maybe to assist in just coming over to Singapore to, collect your remains and or tie up loose ends. Failing to have a will can have significant consequences for your family for that. So what I'm talking about here is the importance of leaving a settled, clear legacy. And in the next slide, what we're talking about here is the wealth structuring options that are available. At Hawksford, we are a trust company, so we run the full gamut of wealth structuring options. I am a private client lawyer, and so I am familiar and have drafted these kind of structures for many years. And most of the time, the conversation begins with, do you have a will? Before you start looking at interesting trusts and foundations, mobility planning, that sort of thing, the obvious question is, do you have a will? Because even if you do have a trust or other more interesting succession planning devices, you will always have some assets which are outside of that. So what you've got on the screen at the moment are the types of options that you have when wealth structuring, with the will being the most important and first. So you've worked hard all of your life. Why leave your inheritance up to chance for yourself and for your family? There are three main reasons why a will is important. The first one is uncertainty and conflict, or rather to minimize the possibility for uncertainty and conflict. Uncertainty because, if you die without a will, then your family are left wondering who's going to get what, how do we divide this, what were your intentions? And conflict because, no question, when you're dealing with money and family, without a solid intention or a plan, there will be conflict. The second one, costs and difficulties of intestacy. So you think it might be something which is a bit too expensive to bother with to do a will now, so you're going to leave it. Actually, what that does is means that your estate will fall into intestacy, i.e. that it needs to be dealt with by the courts. And as soon as you do that, you're starting to rack up significant dollars for your loved ones who have to fix it up. And the costs and difficulties of doing so. So you may have assets in multiple countries. So you're looking at a court process that is likely to be multi-jurisdictional. And then the last one, difficult to locate your assets. So if you don't plan, you may well end up in the scenario which is relatively common, you're living away from your home country. Your immediate family, certainly your extended family, doesn't necessarily know what you own, and therefore when it comes to collecting your estate together, they're not even sure where to start looking. And if it's not found, then eventually it will either just disappear, or it will be left to the state. So here are the reasons why I think that it's necessary to consider whether or not you need a will. There are numerous reasons, but some of the obvious questions that you should ask yourself, if the answer is yes, then you might want to consider a will. The first one, do you have children? I ask that for two reasons. First of all, because you may want to give specific gifts to them, or you may want to set up say when and how they will receive their inheritance. If they're 5 and 7 years old, do you really want to give them all of the cash immediately, or would you rather have a will with some sort of a direction contained in the will that they will receive when they're 25, something like that? The other question about do you have children is guardianship, and particularly an issue for expats who are living outside their home country. The issue there, of course, is that if you are on an EP, for example, and your children are on DP in Singapore, and you die, then your dependents will need to leave Singapore very smartly. You'll need to have pre-arranged your guardianship arrangements. Guardianship isn't it doesn't suffice just to have a note on the fridge, or just I've told this person that they will look after my kids, because that person will not have any legal ability to look after your children. So in Singapore, just as in the UK, there are certain formalities that need to be followed. Very straightforward, but there are certain formalities. And having guardianship in a will is very commonplace as well. Do you live outside your home country for the reasons I've talked about? Do you own assets in multiple countries? So again, that's the issue of can my executor find the assets? So have you planned to have a list or something? And second of all, the law in different countries will apply to different assets. So the will gives you the chance to think through oh, what law will apply to this particular, to the estate in this country, for example. Other ones I'll mention, have you recently been married or divorced? So clearly your wishes will change significantly if you have been recently married, for example, or separated or divorced. Do you have shares in a BVI or other company overseas? Again, that's very important. The shares in their company need to be considered to be transferred. A related issue to that is, particularly in small, closely held companies, is is it intended that your shares will go to your next of kin? The other shareholders of a closely held company, particularly if they're friends or just acquaintances, colleagues, they may not want that to happen. So you know it's a good chance to consider, should I be having some sort of a shareholders agreement? Do you have a complicated estate? So the more complicated, naturally enough, you should plan, and that's what a will can provide for you. I think that's I won't go through each of these. That's probably enough to get the general feel for the reasons why you may want a will. So how in particular would a will help? And I focus on here on the avoidance of family conflict. That really a will sort out your belongings, fundamentally deciding who gets what. You're telling your family who gets what. They don't have to try to figure it out themselves, which could lead to dispute. What to keep, what to throw away, whether it's to keep or sell the house. And of course, it's about cash. It's about money and how you divide that up. Your treatment decisions at the end of your life. One is slightly outside the will. I mean, a will deals with you as once you're deceased. A lasting power of attorney and related documents will deal with treatment decisions at the end of your life, and Stephanie will come on to that. Custody of children, we have mentioned. Funeral arrangements. Some people have very specific intentions. They want to be a donor, for example, of their organs. They want to be cremated and not buried, or vice versa. Some people will even go so far as to say where they want their, they want to be scattered at sea, or they want a particular plot near their family or something. And then family relocation. So wills can also deal with the issue of where you want your family to end up. Let's just touch on what happens if you don't have a will. I reference this as Singapore, the Intestate Succession Act. And what strikes me about this, I'm sure it will strike you as well, is that what happens if you don't have a will isn't necessarily what you would have planned had you had the chance to write your own will. Basically it falls into 4 parts. So rule number 1, if you die leaving a spouse, you have no children, you have no parents, spouse is entitled to the whole lot. That's probably okay. Although in a perfect world, you may want to give a specific gift or something to a brother or a sister or something like that. But that generally works. But from therein, it gets a little bit more awkward. Spouse and children. So where the deceased has left behind a surviving spouse and children, the spouse is only entitled to half of the estate. I have never written a will where the surviving spouse only gets half and the children get the other half. Generally speaking, the surviving, rather the deceased will give everything to the spouse, or most of it, and then rely upon the spouse to look after their children. The next option, rule 3, children only. This makes sense. The children will be entitled to it in equal shares. And then the fourth one is also problematic. Spouse and parents. So where the deceased has left behind a surviving spouse and surviving parents, has no children. Again, the spouse only gets half and the parents take half. So you can see, if you don't want that to happen as the default, then you can have you should definitely consider a will. A will can, you can divide it up as you see fit. You're not bound by these limitations. So I asked at the beginning in the agenda, one will or two. So you've got various options. So often people just have one worldwide will, and if you have assets in predominantly one country, that's fine. You might have stocks in Apple or something in the US, or a few here and there in other countries. So one worldwide will is fine. However, the downside of having one worldwide will is this, and that is that in order for a will to be proven and to be valid, it needs to go through the process of probate. I'll come on to probate in a minute. Probate takes a long time. Typically speaking, you're looking at anything probably, you're very lucky if it's sort of 6 to 8 months, but it's more likely to be a year or more. Some go on for many years. And the issue with having one will, but multiple countries, assets in multiple countries, is that you have to get probate in every country that you have the assets. So you can imagine you're doubling up on each of this long process. So you have assets in Singapore, so you get probate in Singapore, then you go to the UK, get probate in the UK, then you go to wherever it might be, Indonesia, get probate. So that will end up being a very long time. So what you can do is you can have a will for each country that you have significant assets in, and in that way, your executors can run consequentially. They are applying for probate in each court at the same time. They're not having to do one and then the next one. So I just mentioned probate. Let me talk quickly about the process of probate. When you die without a will, it's called intestate, as we saw the Intestate Succession Act. If you die with a will, it's called testate. And the process is getting probate. So as mentioned here, the executor, person named in the will, applies to the court for a grant of probate. And probate is effectively, it's proving the will to the court. It's proving that it's valid. It's proving that the deceased has properly, is dead. And once probate's been issued by the court, it confers authority on the executor to deal with the deceased estate. So with that, you can imagine with a simple bank account. The bank account has been frozen by the bank. No one can get access to it before the probate grant has been issued. Therefore, after probate has been issued, the executor, armed with that grant of probate, goes to the bank, and that's the proof that he needs to then deal with the affairs, deal with the assets. Letters of administration is the same process, but happens when you die intestate. So someone still has to apply to court, a very similar process, but it's a bit longer because there's a few more sort of hoops to jump over. But it's effectively with the same end result. Once you've got your letters of administration, the assets which were previously frozen will be released. And then reseal. Reseal is the process of having a court in a particular country confirm an existing grant of probate or letter of administration. So amongst Commonwealth countries, for example, let's say UK to New Zealand, if you obtain a grant of probate in the UK, you don't have to start from scratch and obtain another grant of probate. All you do is you can reseal the UK's grant of probate, which is a lot faster. But that only works for some countries, typically Commonwealth countries. I'll now pass over to my colleague Stephanie, who can run through this slide.
Thanks, Marcus. Okay, I'll do a quick run through the lasting power of attorney. A short definition, an LPA is a legal document which allows a person, the donor, to appoint one or more persons, the donees, to make decisions and act on his or her behalf. Benefits of an LPA. You can protect yours and your family's interests should they become vulnerable one day. It also allows you to make a considered choice of who you would like to be the decision maker. It alleviates potential stress and, of course, potential difficulties by loved ones of needing to apply to the courts if you were to ever lose mental capacity with no LPA in place. How and what do I need to do? The things that you need to think about are, who are the trustworthy and responsible people around you, who could take, for example, the key decisions to grant. You need to think about these elements. For example, with regards to your personal welfare or property, financial affairs. There are two LPA forms in Singapore. There's an LPA Form 1 and an LPA Form 2. The Form 1 is a standard version that donors use to grant very general powers with very basic restrictions. Around 98% of Singapore citizens who have made an LPA use the Form 1. And the Form 2 is for those who wish to grant donees more customized powers. And there is an annex in Part 3 of the LPA Form 2 that must be drafted by a lawyer. So also beware of some extra costs involved with Form 2. Your LPA must also be certified, so you have to get an LPA certificate, and that will need to be certified by an LPA certificate issuer. They will witness and certify your form. This is obviously that critical safeguard to ensure that the donor doesn't make an LPA under pressure or duress. The certificate issuer will also certify if they feel that the donor has capacity, for example. So, and that element is governed by the Mental Capacity Act. Typically, the certificate issuers are medical practitioners who are specifically accredited by the public guardian, and we can send you across a list separately, perhaps after the webinar today, and also lawyers and psychiatrists. But note that not all lawyers, psychiatrists, and medical practitioners can be certificate issuers. So only certain ones are granted with that power. Okay, how much will this cost? The Singapore government have really been promoting these. It's a simple way to look after your parents when they become mentally or physically incapable. They have waived the cost of Form 1 for Singapore citizens for 2 years until the 31st of August this year. So that's for Form 1, but ordinarily that would have cost $75 for Singapore citizens, and then your Form 2 is $200. Singapore PR, Form 1 is $100, and Form 2 is $250, and foreigners, the price goes up. So for Form 1, it's $250, Form 2, $300. And you can also cancel an LPA. So should circumstances change in the future and you wish to appoint new donees of these powers, you can re-register with a new one, and that only costs $25. Do note, however, that the certificate issuer, so that's the person certifying, that the cost of that can range from about 25 to 80 Singapore. And I believe Marcus will come on later on onto how Hawksford can help you with regards to the completion of these, and also to help processing and the registration as well. Thank you.
Okay, the next one we'll talk through is our will services. So Hawksford provides, we're a trust company, as I mentioned before. We also have lawyers qualified in the UK. So we have the ability to provide a very wide range of services. Our stock and trade as a trust company is trust planning. So clearly we are talking to people who are interested in setting up trusts for succession planning and other reasons. In the wills context, we provide will writing services. We write wills in English. We can also write wills in Mandarin, tailored to suit individual legacy needs. So we do not have templates and standard forms and so forth. As advisors, we will sit down with you. We will have a one-to-one meeting, understand exactly what you need, and then we will prepare a will for you based upon your needs. So that certainly puts us apart from some of the other will writing services where will writers are the ones who are doing it. We're not that. We're providing a much more holistic kind of service. And that's evidenced by the fact that we can fluidly talk about your assets in the UK or Spain or Philippines or wherever you may have, and we can help you craft one will or multiple wills in different countries governing different laws. The executorship is, because we're a trust company, we are also able to provide executorship. What that means is that when you write your will, one of the first things you have to ask, or rather one of the first things you include, is who is my executor? And your executor is any person of mental capacity over the age of 18. It can be a beneficiary. It's usually a member of your family. You may have more than one executor, but it's quite helpful to have a default. And in that case, Hawksford can be your default. So what you don't want to have happen is your executor has died, and perhaps you haven't updated your will. And so when you die, you find that the will is invalid because it doesn't appoint an executor. We provide the service, therefore, just to be that backstop if need be. Trust planning I've already mentioned, and lasting powers of attorney we've mentioned as well. So the lasting powers of attorney, I would just say, we do that for the UK as well as for Singapore. So who is our will writing service relevant for? Our clients are typically living here in Singapore, Singaporeans, PR, EP, holders living here in Singapore. They'll have collected assets while they're here, be it a bank account, all sorts of different things. Or individuals who have some connection to Singapore. So maybe they used to live here, but no longer live here, but still have assets. Maybe they are people living in another country, but they have some other financial connection to Singapore. They might have shares in a Singapore company, or such like. Or they might have formed a Singapore company for their own requirements, but they don't live in Singapore. So the final thing I'll mention is our fees. So we try to keep our fees fairly small for our will services, and we have a very good relationship with St James's Place, so we're able to offer a discounted service to clients of St James's Place. So the service that we provide, you will certainly see a value for money in being able to deal with highly experienced and skilled people. It takes a number of hours to do a will. It will, it'll take at least one sort of, if you like, a Skype call while we're in lockdown. It will take back and forth in relation to your draft. So we'll spend quite a bit of time on it, and we will do that for $850 for a simple will. Typically, we'll have husband and wife, and their wills are usually the same or substantially the same. In which case we can provide a discount. So in that case, mirror will $650 each. If it's a complicated will, and by complex I mean that it may have trust provisions in it for, let's say you have minor children, and you want to give them the asset only when they reach 25. That requires a little bit more time and effort. So our cost for that is $1,200 per will. But again, we will discount that down for husband and wife if it's a mirror. And then the lasting power of attorney, we charge $80 for a lasting power of attorney in Singapore. in the UK. Excuse me. In the UK, maybe I need a will at this stage. In the UK, it's the equivalent but in pounds, so it's slightly more expensive, £80. In the UK, there's a filing fee of £82. That's the government fee. In Singapore, there's a government fee as well. Okay, and that concludes Stephanie and my part. Thank you for your time.
Thank you to Marcus and Stephanie. Just a reminder to everybody, if you do have any questions, please do put them in the chat on the control panel, and then I can field them to either Stephanie, Marcus, or Charles at the end. So I'm now just going to pass over to Charles Edwards of St James's Place.
Good afternoon, ladies and gentlemen. Thank you for setting aside time to spend with us this lunchtime. My name is Charles Edwards, and I'm a partner of St James's Place. So, after considering the emotional and the administrative impact death can have on your estate, then comes the taxman, which can often lead to a huge payday for the government, unfortunately paid for those who failed to plan or who were simply unaware of death tax. The taxman waits for no one, and in most countries this bill must be settled in full before beneficiaries are granted access to their assets, even if it is rightfully theirs. Death duties have been with us for centuries, also known as estate duty or capital transfer tax, and now what is better known as inheritance tax, or the acronym IHT. Irrespective of the name used, the purpose has always and will always be the same, and that's to raise revenue from the estates of deceased citizens. So once considered a tax for the wealthy, IHT now affects most estates more than ever. It will undoubtedly come as a shock to discover that a large proportion of your wealth, which includes your assets, your family home, investments, cars, family heirlooms, and life insurance plans that have not been placed into trust, might actually have to be sold in order to meet the death tax on that liability. So who pays inheritance tax and how much? Well, this differs from one country to another, ranging from the most lenient, which is Singapore, where there is no inheritance tax, through to countries such as the US or the UK, where IHT tax rate is considered excessive. In Europe, the amount of tax that you pay is dependent on the relationship that you have with the deceased. So who pays the tax is dependent on the deceased expression of wishes as stated in the will. But unfortunately, it is the beneficiaries who will ultimately be the ones to pick up the bill. It's important to point out that transfers between spouses or civil partners during lifetime or on death are exempt from inheritance tax. So, as is often the case, the IHT bill will have to be picked up by surviving family members or significant others. So, IHT issues and key considerations. So, your assets could potentially be at risk, not based on your nationality, but in actual fact where the asset is sited. So, a prime example of this is that Singaporeans are the #1 nationality for holding UK property. And often you may think that just because you live in Singapore and there's no IHT here, that makes you exempt. Well, in fact, it's the complete opposite. So if you were fortunate enough to own a property in central London worth £1 million and you were to pass away, you'll be issued with a bill for £270,000 from HMRC before you are even allowed to access the property. So if we were to look at gifts, then you could potentially gift money away. You can have an exempt transfer, and that is when you were to pass an asset to a spouse or a civil partner. You can have a potentially exempt transfer, and this is where you must outlive the life of that gift by 7 years, and the value of this is unlimited. You've also got what's called a chargeable lifetime transfer. Now, this is a gift that's made during the individual's lifetime, which is immediately chargeable to IHT. It does not necessarily mean that there will be an IHT bill to pay, but it does have to be assessed to see if a certain charge will apply. If the amount gifted is within the available nil rate band, in the UK being 325,000, then there will be no IHT due immediately. We've obviously talked about wills today with Marcus, but obviously if you were to die without a will, that's considered to be intestate, and that can significantly alter your inheritance tax status for the worse, meaning that you or your family members have no say on how your estate is proportioned or distributed. When this happens, the intestacy laws of that country will decide on how your assets are distributed on death. This includes bank accounts, investments, property, and any other assets at the time of death. This can be an incredibly emotional, stressful time, and as Marcus pointed out, it can take anywhere between 6 to 12 months to rectify. Now, another important point to make is deemed domicile. And what does that mean? Again, if you live in a country, it doesn't mean you're bound by those rules. So there is a concept called deemed domicile, which is a key to ascertaining if you have an IHT liability or not. In the UK, if you're an individual, but you're not UK domiciled, i.e. you were not born there, but you reside there for 15 out of 20 tax years, then you are automatically considered to be UK domicile, in which case you have to pay IHT on worldwide assets. Okay, so let's look at possible solutions. So what are people's concerns when they consider options to reduce that inheritance tax bill? Well, we've talked about gifting, so you could give up assets, but it might not be the right time to do so. And as a result of that, you might be giving up control or access to your money. We've obviously talked about potentially exempt transfers. So 7 years is the magic number in order to outlive the time of the gift. But in some cases, people don't have 7 years. That could be due to ill health or being physically or mentally incapable. IHT and tax in general has become overly complex over the years, and that's one of the reasons which puts people off the most, is they don't understand it, and so they don't want to address it. And then of course you've got the risk. So what is the potential risk of inheritance tax and a potential bill? Well, in most cases, it's how do you fund the bill? You know, £270,000 on a 1 million property. You know, it might mean that, you know, beneficiaries have to get into debt in order to fund the IHT bill, which is not a nice situation to get into. We also have income. So if you give up an asset, then of course you might then have to alter your standard of living in order to pass the all-important inheritance tax rules. Okay, so when might control of your wealth be required? Okay, so setting up a trust is obviously can be quite a complex process, and it ultimately does take ownership away from you and hand it over to someone else. Again, the concerns around this could be that you have a son that you love dearly, but his taste in partners is questionable. Obviously, if he was to get married, then that person would then potentially have access to half of what you've worked incredibly hard for. You could have a daughter who spends, has a fetish for shopping and potentially will spend most of it before she even hits the age of 30. There could be trust issues with a new son or daughter-in-law that you don't wish to have access to your estate. It might be that you have a relative with special needs. So how do you provision for the income required to be able to provide support for that individual, where in some cases you may not live long enough, they may outlive you. So how on earth do you put in place certain rules and provisions to ensure that that person has the standard of living that they require? Also, we have divorce, okay, which could have a significant impact on someone's estate. And also it's having immediate access to funds upon your death. We've talked about the fact that probate can take up to 6 to 9 months. I think planning ensures that beneficiaries have access to cash as and when they need it. Okay, so what are the options? How do we mitigate against IHT? Okay, so one would be that you could spend it all, buy yourself a nice car, have many holidays, buy various houses in different locations all over the world, effectively meaning that you have nothing left for the taxman to get his hands upon. The question there would be, do you know how long you're going to live? You could gift it to your children, which would seem pretty sensible. But again, we're back to the point about giving up ownership before the time is right. You could take out a life insurance policy to fund the inheritance tax bill. Often people overcomplicate the situation by setting up a trust when they don't actually need to do so. So an inheritance tax, a life insurance would sort out an inheritance tax bill and prevent your children getting into debt to have to pay. And you could also look at setting up a trust. So what is a trust? So a trust is a legally binding arrangement determined by an expression of wishes. If you wish to make a gift to a child or someone you do not believe is sufficiently responsible, you may wish to set up a trust, as that way you can then provide control as to when that individual receives those assets and when. Trusts are a fundamental part of estate planning. They can help in the process of reducing or mitigating IHT, but are also commonly used in helping provide for any liability. The IHT treatment of trusts at inception and during the term of trusts and upon distribution of assets really depends on the type of trust that is used. Okay, so let's look at the third option, which is life insurance. So there may be a number of reasons why it's not possible to reduce the size of your estate and a potential IHT liability. So what can you do about that? Life insurance plans can be used to provide a tax-free lump sum upon death to meet any liability. Life insurance plans can provide cash on death, but it's also important that if they're not placed into trust, the issue there is that the person that inherits the cash can then have their own inheritance tax liability. So it's important to consider trusts when setting up a life insurance policy based on the reason and the purpose for setting it up in the first place. So it does not provide a solution for IHT, it merely funds it rather than funding out of your own assets. Okay, so St. James's Place, who are we? Well, we were set up in 1991 to provide personal face-to-face advice. We're a FTSE 100 company with over $200 billion of client funds under management, and we have in excess of 700,000 clients worldwide. We provide a wide range of high-quality services to clients, both individuals and businesses. At the heart of the business at St. James's Place is the partnership, a group of the most experienced, able, and highly regarded professionals working in wealth management today. St. James's Place Partnership has on average 18 years industry experience and build long-term relationships founded on trust, service, and commitment. We also provide a guarantee of advice. So this is an additional layer of protection that supports every recommendation made by a partner to ensure the advice given is best suited for each individual and their own set of circumstances. Thank you for your time. I'll hand back over to James now.
Thank you, Charles. Very insightful. Could I just ask if anyone does have any questions, that they do add them into the chat. So if I can just ask Charles, Stephanie, and Marcus just to unmute their microphones for a moment. Just a question, first of all, I think for Marcus. So Marcus, what would be the situation if the executor is a child or perhaps a young adult? Who would be there to assist them in court?
So the executor needs to be an adult. So it has to be a mentally competent person of majority. So that scenario is not going to arise.
And if they are perhaps a young adult, so maybe a sort of 20, 25-year-old?
Yeah, actually, sorry, I should amplify. What typically happens in practice is that the executor will essentially pass everything over to an advisor. Now, and then that advisor is the one who will go through the process of obtaining probate. So the most, the usual example is that they'll give it to their lawyer, or Hawksford provides the service as well. I'll give a specific example of I had a relatively recent death in my family. My aunt died in New Zealand. I was the executor of her will. I live in Singapore. What happened in practice was that we appointed her longtime family lawyer to be the advisor, but to obtain probate. He prepared all of the documents for me. He would send them over to me. I would look at them and then check it and then sign it, send it back to him. The process of probate isn't not generally in any event a one where there's any standing up in court. It's not that kind of a proceeding. It's all sort of done by the papers. So this chap filled out all the required forms, sent them into the probate registry. So although you're the executor, you're not actually the one doing all of the work.
Thank you. And just another question. What's the situation with regards to Muslim and Sharia law and wills?
So in Singapore, that's dealt with by a separate law. Hawksford doesn't get into dealing with that. We do have some Muslim lawyer advisors contacts that we can put Muslims in touch with, but we don't draft wills for Muslims specifically.
Understood. Okay, thank you. And what is the process? So we've talked about wills for common law countries. What about countries that are not common law?
So yes, I mean a lot of the world is not common law. So you look at Europe, for example, most of it's civil law. Generally speaking, civil law countries have the civil code, and wills are much less common in those countries because they are still possible, but the civil code sets out forced heirship, if you like. So forced heirship being you are required to give your assets in particular proportions to particular people, and that's set out in the code. So you find then that that's not something that's particularly easy to get around. You can't just write a will over those assets. Where it gets interesting is where your domicile is common law. So say, for example, you're UK domiciled, you haven't lived there for a long time, you might live in Spain, for example, but you still will have you still want to have a will, and you're still entitled to a will because your estate is divided according to your domicile, not your residence, and therefore you may well have a will that covers Spanish property, even though Spain itself, is a civil law country, and there are rules about to what extent Spain will recognise the common law will. And we can work through the process. We have a number of clients that we deal with, as you can imagine, that have assets in Indonesia, Philippines, Spain is one of them, Italy is another one that we've dealt with. So, and there are rules in place to facilitate your request under your will being honoured, even if it's just.
Perfect, understood, thank you. So a question for Marcus and perhaps Stephanie as well. Would there ever be a scenario, and perhaps why, would you ever write a trust instead of a will, given that the Form 2 for lasting power of attorney is customizable?
Perhaps I can. Okay, go ahead, Marcus.
No, Steve, I was going to say, over to you first.
Okay. Well, the LPA applies only when you are alive, and then the will only then applies after your passing. I think that's probably the main point there. Marcus, I don't know if you want to just speak a bit about the trust provisions inside a will.
Yes, so it's not intended that the lasting power of attorney will replace trusts and the idea of a trust. A trust is a much more comprehensive scenario. You can have a trust, and we provide them for during your lifetime. If you want to have a trust, set up during your lifetime, that's fine. We can do that. Alternatively, you can set up a trust or have one within your will on your death. Lasting powers of attorney are much more specific kind of things. They're designed to give someone absolute control over your assets in circumstances where you are unable to do so yourself. So in circumstances, your incapacity, for example. So that's a lot narrower than what a trust would be.
And with regards to guardianship, what would happen, Marcus, if parents were to pass away in Singapore without nominating guardians?
I suppose there's a practical answer to that, and maybe that's the most important one, is that a child can never go without someone to look after them, and the final decision maker of that is, of course, the Singapore court while you're here. But in practical terms, even if you didn't appoint someone as a guardian, that a person will need to take care of the children. Now, if there's no one being nominated and there's no one around, then social services will need to step in. Singapore government will need to step in. But that is a horrible situation. So clearly, the parents are under an obligation to ensure that there is at least somebody to take day-to-day care of the child. The reason why a more formal guardianship should be considered is because that gives legal rights for a person to look after a child. So you can imagine a very simple scenario of that guardian needs to apply for an extension of time on a dependent pass or something, or some sort of other compassionate grounds to stay in Singapore for a bit longer. So perhaps the child can't sign it themselves. So there needs to be some sort of a legal authority for someone to be signing on their behalf. Or they might want to take the child out of the country, and they get stopped at ICA and ask questions about what basis do you have to take this child. So there's the practical issue of you're under an obligation, really, moral obligation to ensure that someone is around to look after the kids. But you ought to consider going to that next step and actually giving that person also legal rights. My view is that there's usually a temporary guardian and then your more permanent guardian. So the temporary guardian is that person who's going to look after your child immediately. That person might only be a guardian for 30 days while the child is still in Singapore. And then the sister or the parents come over to Singapore and collect the kids. And then let's say you've drafted up a deed of guardianship, your temporary guardian steps away, and the next guardians who you intend to properly look after your children for the rest of their minor life take over.
Thanks, Marcus. And just relating to that, what would you say, I guess, the normal or the majority age is where a guardian is no longer required?
Oh, so the age of majority differs from country to country. Generally speaking, you're either looking at 18 or 20.
Understood. So this is a question for Charles. If someone is UK domiciled and has assets in the UK as well as elsewhere, Singapore being an example, how is that considered for taxation?
So from a reporting standpoint, James, if you had assets cited in different locations, you'd have a responsibility to each one of those authorities to report those assets. That doesn't mean that you would necessarily have to pay tax on them, but you do need to register it with each authority, so that in the case of your death, that's obviously how they would calculate a potential inheritance tax bill.
So it could be the scenario where if someone is deemed domiciled in the UK but has assets in Singapore, the Singapore assets are liable for inheritance tax.
Correct. And that's why we have all sorts of weird and wonderful acronyms now, such as FATCA and Common Reporting Standards, also known as CRS, whereby financial institutions talk to one another as well as governments, so that if you were to pass away in one country, it could mean that, depending on how long you've stayed in that country for, it could mean that you have an inheritance tax bill on worldwide assets.
Understood, thank you. And could you just elaborate on how insurance would be used to mitigate that once more, please?
Yeah, so it's a fairly simple calculation to make. Husband and wife both have individual inheritance tax allowances of 325, so 650,000. Effectively, if you have assets in excess of that value, then there would be a 40% charge applied on assets. So what we would do is we'd work out what the actual IHT liability is, and we'd then take out a sort of an individual policy on the husband and on the wife for the whole of life, so that if either one of them was to pass away in the future, then money would be released. It would be paid into trust, and obviously if they had children, the children would be beneficiaries, and the money would then be payable to the beneficiaries, who could then satisfy the inheritance tax bill.
Understood. And is there any additional cost for a trust within a life insurance policy within a trust?
There isn't. No, St James's Place has a range of trusts that we could utilise, but in most cases, the life insurance company has their own trust that we could wrap the life insurance policy into.
Perfect, thank you. This might reference back to one of your previous questions. Do US citizens who mostly live in Singapore, will they still be subject to US taxes on death?
Well, so in the US is incredibly complex when it comes to tax. What I will say is that if there's any assets held in the US, there would be withholding tax applied to it. And that can range from anything from 35% down to 15%, dependent on the age that you are when you come to claim that asset. But yeah, ultimately the US will hold a tax liability against any asset that you hold in that jurisdiction. And if you don't have a will in place and you were to pass away, then you would then need to satisfy probate in the US to gain access to those assets.
Thank you. So for an individual that has most of his or her assets within the UK, that also has a UK will, but investments in Singapore, is there still need for a will in Singapore or any additional trust planning?
Well, in my opinion, you would have, the best advice would be to have a will in each jurisdiction of where that asset is cited. And the reason for that being is that you can submit multiple wills at the same time in order to gain access to granted probate, access to the assets. So if you do have assets in Singapore, it would make sense to speak to Hawksford and Marcus in order to set up a will here that would determine how your Singapore assets are distributed, and also have a will in the UK that would determine how your UK assets are distributed. And you could have an executor in both locations, again, to save on time, to ensure that this gets done in the best possible, shortest period of time.
Perfect, thank you. And just one final question for Marcus. I'm conscious that it's 8 minutes past 1. So if husband and wife jointly own a property and one of the individuals passes away, does inheritance tax apply to that person's share of the jointly owned property? And if so, when is it payable?
I think that's a question for Charles, isn't it? The IHT point.
Over to you, Charles.
Just run that one past me again, James. Go on.
If a husband and wife jointly own a property and one of the individuals was to pass away, at what point is the inheritance tax chargeable?
So the inheritance tax isn't chargeable until the second person passes away. So the second spouse would have to pass away before it's then chargeable. So it's effectively deferred. And then we're back to the same situation of then the beneficiaries would then have to settle the IHT liability.
Perfect. Thank you. I'll just have one final question come in. So this one goes back to Marcus. How can all of this be facilitated during lockdown? So how can one write a will as well as the process of completing forms for lasting power of attorney?
Right. So yeah, I mean, as you can imagine, we have done a lot of wills in the last few weeks because of people being concerned about their own mortality. As similarly for lasting powers of attorney, people are concerned about ending up in hospital, and you know, people need to be able to still deal with their affairs, financial or otherwise. So from our perspective, we can have an initial meeting. Either we can have a telephone call to have a conversation and then take your instructions, or we can have a video call to do the same. We can write the will and email it to our client. They have a look at it. We can have a talk about it, email back and forth if required. And then we send out by email the final version. Now the will does need to be, when it comes to signing it, the will needs to be witnessed in the presence of two independent witnesses. That's where we're going to have a problem in lockdown. You know, whilst there's a prohibition on gatherings in Singapore, so 3 people meeting together in close proximity would not be permitted. So that's the issue really. Is you will need to, you know, I don't know, have a table somewhere or park bench or something, and you sign it and then move away, and then the other witness signs it and then moves away. That's kind of what we've seen so far.
So it is feasible.
Feasible, but as I say, it's the 2 independent witnesses bit, which is proving to be the challenge.
There's certainly no harm in starting the process.
Yeah. The lasting powers of attorney are much more straightforward because you don't have that same level of formality. You don't need to have this 2 independent witnesses bit.
Okay, thank you. So I'm conscious it's 11 minutes past 1. So thank you to Marcus, Stephanie, and Charles for answering the questions. So just in terms of future events, great to have you guys on the webinar. So thank you for joining and taking up your lunch hour. We do have some upcoming events which we can share with you. So just on the screen is just a few upcoming programs that we have. Do feel free to get in contact if you would like to be included on the distribution list for those. So thank you very much. What we shall be doing is also sharing with you a feedback form, so please do complete this. And we can also share with you a recording of this webinar as well if you'd like to distribute it. So thank you all and have a good day ahead.
Thank you.